Everything just shifted in a way few people saw coming. Ivanka Trump has now been hit with a federal subpoena that could redefine the entire Trump Organization investigation. A sitting judge has ordered her to appear for sworn testimony within 10 days. A move legal analysts are already describing as the most consequential escalation since the first criminal indictments were handed down. This is not a procedural formality or a paperwork dispute. It is a direct court order driven by newly surfaced evidence so serious that prosecutors persuaded Judge Arthur Engoron to cut through standard delays. When a federal judge compels testimony from a former first daughter and attaches the threat of immediate arrest, it signals that something deeply consequential has landed on the court's desk. Stay with me because what you're about to hear explains why this moment matters more than anything that has come before. So, what triggered a step this extreme? According to multiple sources, it was an internal memo leaked from the Trump Organization's former accounting firm that allegedly ties Ivanka Trump directly to fraudulent property valuations during her time as executive vice president. People who have reviewed the document say it includes her personal signature on at least 12 instances of inflated asset values that were later used to secure favorable loan terms. This goes far beyond political controversy or family drama. Reports suggest even members of her own legal team are urging immediate cooperation to avoid criminal contempt. And when a judge sets a 10-day deadline and backs it with arrest authority, it's a sign that prosecutors believe the situation has reached a critical point. To understand how things reached this stage, you have to look at what's been unfolding behind the scenes. For months, tensions between the Trump Organization and Manhattan prosecutors have steadily intensified. There have been disputes over document production, repeated claims of privilege, and clashes over court-ordered deadlines. What began as a broad inquiry into business practices slowly narrowed into a focused examination of specific financial transactions involving inflated asset values used to obtain favorable lending. The turning point came during what was initially described as a routine review of records provided by Mazars USA, the Trump Organization's former accounting firm. Legal sources say Mazars had been cooperating with prosecutors since October 2024, turning over thousands of pages of internal emails, property assessments, and financial projections covering the years 2014 through 2021. Everything changed, according to those familiar with the process, on January 15th, when a confidential accounting memo surfaced during discovery. Prosecutors now describe that document as evidence of a systematic pattern of financial deception stretching across nearly a decade. The memo, which had been shielded under attorney-client privilege until a recent ruling overturned that protection, is being called the clearest evidence prosecutors have obtained so far. Dated December 2019, the memo reportedly lays out instructions attributed to Ivanka Trump directing the inflation of property values at Trump Tower, Chicago, Trump International Hotel in Washington, and Mar-a-Lago by more than $40 million. Sources say it includes side-by-side calculations comparing internal valuations with the figures presented to Deutsche Bank and other lenders. Prosecutors argue this was not aggressive accounting or a difference of opinion. They say it reflects intentional misrepresentation designed to mislead banks. The memo allegedly even acknowledges that the inflated numbers did not match market assessments, with handwritten notes suggesting awareness that the figures were inaccurate. Things escalated sharply the next day. When prosecutors presented the memo to Judge Engoron during a sealed hearing on January 16th, observers say his reaction was immediate and unusually forceful. Court staff later described him as visibly unsettled by what he reviewed. That reaction reportedly led directly to the emergency subpoena and its accelerated timeline. 10-day federal subpoenas backed by arrest authority are exceptionally rare. They are not issued over technical disputes. They are used when a judge is persuaded that criminal conduct is evident and potentially ongoing. What followed only underscored the seriousness of the situation. Early on the morning of January 17th, federal marshals arrived at Ivanka Trump's Miami residence to serve the subpoena in person. Witnesses described 3 black SUVs pulling up to the Star Island property around 7:30 a.m., with agents remaining inside for nearly 2 hours. According to reports, Ivanka's private security initially attempted to delay service, claiming she was unavailable. That effort reportedly ended when the lead marshal warned that interfering with federal service carries separate criminal penalties. The marshal overseeing the operation, identified by sources as Deputy Marshal James Rodriguez, is a veteran known for handling high-profile cases involving uncooperative subjects. Neighbors later told local media that the normally quiet enclave drew unusual attention as the standoff dragged on. Security footage from nearby properties allegedly captured repeated calls between Ivanka's security team and legal advisors while agents waited. When additional marshals arrived around 8:15 a.m., bringing the total number of federal agents to 12, it became clear authorities were prepared for resistance. By 9:45 a.m., Ivanka Trump accepted the subpoena along with an evidence packet said to exceed 200 pages. Those present described her as visibly shaken during the exchange, repeatedly asking about the deadline and whether extensions were possible. The subpoena requires her appearance before a grand jury on January 27th, with testimony specifically focused on her knowledge of valuation practices, communications with Deutsche Bank, and her role in securing a $125 million credit facility prosecutors now claim was obtained through fraudulent representations. Legal analysts note that such narrowly tailored demands usually indicate prosecutors are filling in precise gaps, not fishing for information. Court filings released shortly after revealed another critical detail. The subpoena includes a sweeping evidence preservation order requiring Ivanka Trump and her representatives to retain all documents, messages, and recordings related to Trump Organization valuations from 2014 to 2021. Any violation of that order could lead to additional obstruction charges carrying penalties of up to 5 years in prison. Then came what many are calling the most damaging revelation of all. According to sealed court documents later obtained by several outlets, the accounting memo contains handwritten notes experts have identified as Ivanka Trump's. Those notes allegedly include instructions to maximize projected values in Chicago and ensure Washington figures supported financing terms previously discussed. Prosecutors commissioned a handwriting analysis conducted by Dr. Financing Margaret Stevens, a veteran forensic examiner with decades of federal court experience. Her conclusion reportedly found a 97% match between the notes and known samples of Ivanka's handwriting from contracts and White House documents. But the evidence did not stop there. Prosecutors also revealed that the memo references audio recordings previously unknown to investigators. Sources say Ivanka had recorded conversations with accounting staff, believing they would protect her if questions arose later. Instead, prosecutors claim the recordings directly demonstrate criminal intent. Transcripts reviewed by investigators allegedly capture Ivanka acknowledging that the figures presented to banks differed sharply from internal assessments, stating that the numbers were optimistic but necessary to secure favorable terms. Additional recordings reportedly document conversations with Deutsche Bank representatives where inflated values were shared despite private acknowledgement that they were best-case scenarios. White-collar crime specialists say recorded admissions of intent are extraordinarily rare and often decisive. Manhattan District Attorney Alvin Bragg's office later confirmed the subpoena in a carefully worded statement, noting that recent developments revealed compelling evidence of criminal conduct requiring immediate testimony to prevent ongoing harm to financial institutions. Legal experts emphasize that the phrase ongoing harm is significant, suggesting prosecutors believe either the conduct continued recently or that failure to act could enable further deception. This moment also stands apart from prior investigations involving Trump family members. Donald Trump Jr.'s Senate testimony in 2017 focused on political contacts, not financial crimes. Eric Trump's civil deposition in New York allowed him to invoke the Fifth Amendment without immediate legal consequences. Ivanka's past congressional testimony regarding January 6th was carefully limited. This case is different. Prosecutors now claim to have documents and recordings directly tied to her actions. According to financial crime experts, the evidence presented to Judge Engoron likely met the threshold for emergency action because it suggests intentional deception, not judgment calls. The memo reportedly includes explicit acknowledgement that external figures differed from internal valuations, with notes marking them as numbers meant for lenders. Prosecutors argue this shows deliberate misrepresentation designed to secure financial benefits. The implications extend far beyond one family member. If it is proven that Ivanka Trump knowingly participated in financial fraud while serving as a White House advisor, it raises unprecedented questions about conflicts of interest and accountability at the highest levels of government. She now faces a stark choice: cooperate and potentially implicate herself and her father, or invoke constitutional protections while prosecutors pursue additional charges. Legal analysts say there is little middle ground. If the documents and recordings are authentic, denial becomes difficult. If they are fabricated, it would require believing multiple institutions coordinated false evidence against someone largely absent from public controversy for years. Former prosecutors across the political spectrum have described the allegations as extremely serious, with potential charges including wire fraud, bank fraud, and conspiracy, offenses that often carry lengthy prison sentences. Inside Ivanka Trump's legal circle, panic is reportedly setting in. Emergency strategy calls over the weekend included prominent defense attorneys debating whether cooperation could limit damage or whether silence offered the only protection. Some advisors reportedly worry that joint defense agreements could collapse if prosecutors offer Ivanka immunity in exchange for testimony about others. Meanwhile, Trump Organization board members are said to be seeking independent counsel, with some even considering resignation as the risk of expanded charges grows. Public reaction has been explosive. Supporters argue she is being targeted unfairly, while critics see the case as a test of whether powerful families are held to the same standards as everyone else. Donald Trump responded by attacking prosecutors and the judge, rather than addressing the evidence itself, a move legal experts say can backfire by drawing attention away from factual defenses. At its core, this case is about more than accounting memos or loan documents. It is about whether proximity to presidential power shields individuals from accountability. Ivanka Trump now has until January 27th to appear before a grand jury or face arrest under federal warrant. Prosecutors are reportedly preparing additional subpoenas, and the outcome could redefine how the law treats those closest to the presidency. This is not a story that fades with the next news cycle. It is a reckoning unfolding in real time, testing whether the justice system applies equally, even at the highest levels. The evidence has been presented, the subpoena has been served, and the countdown has begun. What happens next will shape not only this case, but the expectations Americans hold about power, responsibility, and the rule of law.